case, the pleading that on residential assent is in petition 23 ground F. There's a reference to the residential assent not protecting the act.
Petition 20?
Petition number 23, the lead matter.
That's right.
Ground F.
Ground.
Page 54.
Lead matter is 24. 23.
Reading as to
Residential assent is not saving the act from repugnance. There's a pleading.
yes.
Yes, because I appear for the petitioner in writ petition civil 1011 of 2017. My challenge is confined to the Tamil Nadu Act.
1 minute. 10.
1011 of 2017. The respondent is the state of Tamil Nadu. My challenge is only to the Tamil Nadu Act. Now, responding to what Justice Rastogi had mentioned a short while ago, I wanted to just indicate what my points and the thrust, to use your lordship's expression. What's the thrust of my submission is going to be? I'll state that first. I'll also like to indicate what I am not going to canvass, so that the scope is narrowed to whatever extent. And thereafter, I'll indicate as to how I plan to proceed. Now, my thrust is 3 or 4 points. It falls truly under this expression which was used and on which your lordships have framed a question, colorable. So the exercise, the Tamil Nadu Act amending the Prevention of Cruelty Act is a colorable exercise, and I'll just list the points. The first point is it completely seeks to destroy or is contrary to the well-entrenched principle of separation of powers. This is my first point. Second, the issues regarding cruelty, brutality, as far as Jallikattu and racing, etc. is concerned, have attained finality. And a very important principle repeatedly laid down by this court is that once matters attain finality and certainty, the credibility of this institution itself is founded on the fact that there is a certain conclusiveness to a final order which is passed. The third limb of the submission is going to be that we have now an emerging doctrine called, it comes under 2 names in international law. It's been adopted by this court. It's called non-retrogression or the progressive realization of rights. Under our constitution, which has been held to be a living document which responds to the changing times, we have progressive realization of rights. Rights move forward, they don't go back and shrink. So that's going to be a third limb. The fourth limb of our submissions is going to be that there are findings of fact, which I will take you to in the judgment in Nagaraja, but keep that aside. There are subsequent facts which we have placed on the record in the form of, on affidavit, in the form of site inspection reports as to what is happening with regard to Jallikattu. And what you will find is that there is no difference. And now I am making the point. The point is our science and understanding regarding sentient creatures. So I'm not talking about trees. I'm not talking about mosquitoes. I'm talking about sentient creatures that has advanced since 2014. And if anything, it should reinforce, or that will be our effort to persuade you that it reinforces the directions which Nagaraja has already laid out and which Nagaraja already points to. Finally, this was an interesting question which was posed in the first day. And the question was, in theory, can the Prevention of Cruelty Act itself be fully repealed, etc.? What happens then? 1960. Or number 2, supposing, and I must answer it, so I'll answer it right away and then I'll elaborate on it. Or number 2, supposing Parliament brought this act, so that, we don't have all those problems regarding legislative competence, etc. We must consider those aspects. So I'll give you my answer first and then I'll try and justify. My respectful submission is that apart from progressive realization and non-retrogression, let us assume that Parliament first and foremost repeals this act. Point 1, it's just repealed. 1960 Act is taken away. What happens then? My submission will be that having regard, and I'm of course in my theoretical situation saying that it is not reenacted in some form, correct? We are just theoretically not reenacted. My submission will be the constitutional guarantees, 1, the principles articulated by this court in Nagaraj and other judgments is sufficient to nevertheless protect animals and bulls in particular from Jallikattu? That's going to be my answer. So it will not make a difference whether Parliament can't bring it down, but that's another separate issue. But even if this is repealed, we now have sufficient traction on the principles laid down by this court on constitutional principles and on the evolution of the law and our understanding and sensitivity as far as sentient creatures is concerned, that even if this act goes, this type of a practice would meet an embargo if we are correct. Then I would like to respectfully submit that then your lordship correctly put to me. So 21, let me just, there may be other facets to 21, but I'm just mentioning my facet. Mine is a very limited facet to 21. My first facet to 21 is that human beings die in Jallikattu, and we're going to place that on the record. And they suffer injuries. Number 2. So there is clearly direct impact on 21. That's my first submission. My second submission is going to be, we understand that there's a certain penumbra of rights which have been developed by this court under Article 21. For example, the right to a wholesome environment. I'm just giving it. There's no express articulation, but it gradually came up through judgments of this court. And now in July this year, 4 decades after this court articulated, or 3 decades later, the United Nations General Assembly has also now passed a resolution, unanimous resolution of the United Nations General Assembly saying that everyone has a right to life, a right to a healthful environment under the aspect of right to life under 21. So the point over here is, the first submission is people are injured and die, 21. And the second element is that in this penumbra, your lordships have read various rights. So it is, so now let me just tell you straight away what I am not canvassing. I am not canvassing personhood for my purposes. There may be other counsel, etc. So I'm not giving it up, etc. But at least I will not detain your lordships on that line of argument. So I'm not suggesting that 21 is something which is that the bulls, etc. have an Article 21 fundamental right. Indeed, I am content with Nagaraj. And the Nagaraj judgment and what hasn't been placed, or at least my understanding is that it hasn't yet been placed, the very all-important review judgment of this court in Nagaraj as well, which I'm going to place before you. So that will give a complete idea. But what's the point? The point over here, therefore, is that as far as 21 is concerned, I have mentioned my point. 14 applies in different aspects. 14 will apply, Mr. Luthra mentioned it to the court, and that's the classical test. That look, if you have bulls as a species, then where is the question of distinguishing between? It's an artificial distinction with no realistic object or rational object, or a rational connection to the object sought to be achieved, which is you're excluding certain types of bulls for the purpose of protection of the Prevention of Cruelty Act, etc. That is the classic classification test. But I'm just flagging, because just now I'm only flagging the issue. There's one very important principle this court has laid down, an aspect of Article 14, and I'm going to confine myself mostly to Constitution bench judgments, except in 1 or 2 cases. In 2 Constitution benches, your lordships have held that even, I'm sorry.
You're appearing for
for the writ petitioner.
There is Animal Welfare Board.
No, it's the People for Ethical Treatment of Animals, PETA, India versus State of Tamil Nadu, writ petition 1011 of 2017.
It's a body association.
Yes, and it's a registered society. I'm obliged. So, sorry. So, allow me to just flag the issue.
Yeah.
Let me just state the issue. The issue, I'm only on Article 14 now. On Article 14, this court has laid down that even before we come to the classification test, if your objective is per se illegal or discriminatory, I'm using the language of this court. Under Article 14, if your object is illegal or discriminatory, it will be struck down. The action, whether legislation or executive, will be struck down before we even come to the classification test. And I am therefore, apart from the separation of power point, etc., finality of judgments, etc., going to try and urge and persuade your lordships that this object itself, having regard to the development of the law, may not be a valid legal object, and the object itself is discriminatory. So this is going to be the broad heads of submissions, then Manoj, I'll develop them quickly. So I have also mentioned to the court that as far as, now I'm just 2 more points. First question, and then I'll get straight into the judgments. The first point I want to mention is, that for my purposes, Nagaraj in its operative directions urges Parliament and says perhaps the time has now come to elevate animal rights to a constitutional status. Your Lordship may recall that particular direction, which is given by our court. So I am content with that, in the sense that I am content that it is not housed in the Constitution as such, as an animal right. Of course, there are directive principles, etc., compassion, all that is a separate issue. But I am content with saying that, look, this is the state at which we are, and Parliament hasn't brought in a subsequent act. So I am not going to read into the statute, into the constitutional provisions, any animal right as such. That does not mean, however, that there are certain now, I mean, I'm using the word, I think, a little overbroad, but I'm fortified by your Lordship's judgment. There are 5 sets of freedoms, for example, which have been recognized more or less universally in the context of animals. 5 freedoms, nothing to do with the Prevention of Cruelty Act. These freedoms have been recognized globally in the science, in the literature, and in, it's not appropriate for me to use the word the civilized world. That's not a correct expression. But with the march of civilization across the world, these 5 rights have been recognized. And I will place those before you because they've been recognized and enumerated in Nagaraj itself. So this is one particular element. And the final point I want to make is on legislative competence. Speaking for myself, I believe that it falls under entry 17 list 3. Correct. So there will be others who may canvass and say that, look, this is that the state has no legislation. Whether they can't do it for a variety of other reasons, but I am not going to press, so that your Lordships know at least the scope of my my submission. So these are my submissions. Now what I plan to do is 2 things. I want to take you through certain paragraphs from Nagaraj's judgment first, and then I want to take you through the review judgment which has not yet been placed before the court. And I want your Lordships to keep one thing in mind. The judgment in Nagaraj's case turns on facts. This is the most important submission. It goes on facts. There's a determination and a conclusive determination, according to us, on a factual foundation. Now, this has important repercussions on 2 elements.
नागराज का रिव्यू इस नहीं है रिव्यू नागराज का रिव्यू
Everything, volume 7.
main document is there but the review judge
Now that you've given up this Article 21 first.
I am not, Manoj, giving it up, Manoj. There will be others. I am not going to address your Lordships. I believe I am assisting the court, but I won't assist your Lordships on that.
So
Yeah.
we have to proceed on the basis of your assumption.
Yes, yes.
Which is that you are not really proceeding the argument of personhood. Under Article.
Yeah, I'm not going to take up your time at all on that.
If that is so,
Yeah.
before you go to
Right.
I have to ask you.
Right.
See, the judgment is based on a framework.
Yeah,
That framework was the 2009 Act.
yeah, quite right.
And the 2009 Act was
Yeah.
struck down as being repugnant.
the review judge
Inter alia. But you're absolutely right. The answer is yes, it was struck down as repugnant, but there were a whole host of other findings on facts which were also entered.
Just asking you, just imagine
Yeah,
for a moment
yeah,
that the court had before it
yeah,
this act
yes,
at the time.
yes.
That is the act
17 Act.
which you say
Correct.
falls under list 3
Right.
and it has
Right.
a legislative power.
That's a good approach. Yeah. Yeah.
So because that's how we can.
No, absolutely right.
So if that were the statutory framework,
Yeah.
would the decision have been rendered, number one, on the same line?
It would have been, the conclusion would have been the same, but obviously they would have struck down this particular thing, and the repugnancy and legislative conflicts argument would not be there. That would not be there. That repugnancy argument and conclusion, it's one of the several conclusions which they reach, that wouldn't be there. I agree with you. I think that's a good way of testing it.
But then what would be the basis for the court to approach the issue then?
No, I think the court, what your Lordship is putting to me is that forget the 2009 Act. They didn't go through a separate, the state legislature did not go through a separate act route.
Yeah.
It went instead through an amendment of the Parent Act route, which is exactly what they've done here.
Exactly.
The question being put to me is, would the outcome have been different? On my understanding of this judgment, the outcome would not have been different, save and except one aspect. That with regard to the repugnancy argument, there would have been no discussion and there would have been no conclusion because that would not have arisen.
No 21 argument. No Article 21 also, because we have.
So 21 would have been there because the court finds that people have been killed in Nagaraj. That hasn't been read to the court. The court finds that people are being injured on the ground, and my 2022 report also says the same thing. Every year people are dying over there. So there's a clear 21 issue. But not the personhood one. That I'm not going to say. It does. I don't read Nagaraj to say, to elevate it to personhood. The court is very disciplined in my respectful submission, and correctly so. But it reaches, yes, I'm sorry.
Oh. So far as this Jallikattu and
Yeah,
there's such certain death has taken place,
yeah.
but we are examining the prevention of cruelty to animals.
Of course you are.
If anybody die in the Jallikattu
Right.
function,
Right.
which is not the question before us.
No, I'm just, Your Lordship, that's not the question is, the issue is, parties have come under 14, which we've explained. Parties have also come under 21. Because the embargo, which was placed by this court in its judgment in Nagaraj, and which is reaffirmed, because I'm going to take you to the review judgment as well, and reaffirmed in the review decision, comes to the conclusion that this particular practice is something which must be stopped. One, because it's in violation of the Prevention of Cruelty Act, because it impinges and visits huge amount of cruelty and brutality on the animals themselves. And second, it also impinges and impacts human beings by causing injury, etc., etc. That's expressly found here. And it's based on facts. So we'll come to that. Sorry. Yes, of course, of course. Yes.
When you talk about cruelty to animals,
Yeah.
to the human beings.
No, I'm not saying cruelty to human beings. I'm saying 21.
21.
Yes.
21 is defining. You said that.
Death and injury.
Death and injury.
Right,
Exactly.
right.
Death and injury. We are
Yes.
taking it. You take the case again, we go back to the example of a boxing match.
Yeah.
So the argument, when we put this to Luthra, his
Yeah.
argument was,
Right.
there's a distinction because in the case of a human being,
Yeah, he said there's agency.
agency, and he's consenting to it,
Yeah.
he's agreeing to it.
Yeah, all right.
He's agreeing to it.
Okay.
So when the human beings who are dying, are
Right.
obviously they are agreeing to it because they are agreeing to it.
No, I don't know about agreeing to it, but anyway.
That is the argument.
No, they are there for agency in the sense nobody's forced them to go and watch the Jallikattu. That's the point.
Exactly.
That's why I'm not saying no.
No, if that is so,
Right.
would you want this example in the
Right.
extent that tomorrow we'll have to put an end to boxing match?
No, I'm not asking you to put an end to boxing at
Why
all.
not?
We'll just confine ourselves to Jallikattu. I have some little bit of understanding on that. So we'll try and help you there.
How will you, I'm not paid myself here. What I was saying is, take it to that level.
No, don't take it to that. No, don't take it to
You
that.
cannot.
No, you don't take it.
You can't have it.
No, you please dismiss my petition, but don't ban boxing. For whatever reason, we must confine ourselves as a constitution bench. The discipline of this court invariably is to decide on the narrowest possible issues.
Exactly.
And I think that's a system which we long followed, and I commend it to the court. So let's keep boxing for another day and another case, if it ever comes up. So,
But you have not answered my question.
no, I am not saying, I am saying that 21 peripherally arises in my submission. My primary submission, that's why I'm answering it threadbare. I am not saying that 21 front and center is the point I am going to canvass. I am not going to canvass it because I have said that I have retreated from the submission of personhood as far as bulls are concerned. If there's no personhood, there is no 21, at least as far as the bull is concerned. Then where is the 21? So 21 is in the context of spectators, and there is an element which you will find in this judgment and which was referred to. There's an element of humanism. That's a very important point. There's an element of compassion. That's a very important point. It's a duty and an obligation under our constitution. And in that context, probably 21 comes in, whether the person is injured or not. So these are dimensions which your lordships will be alive to. But I mean, you'll be alive to it. I don't want to put it any further than that. This is the broad background of what my submission. Yes, I'm sorry. All right. So then, may I just take you? Sorry. Yes, of course.
Sometimes what happened?
Sorry.
There are 5 issues arising
Right.
subject.
Yeah.
And out of 5, I'm not satisfied on one of the issue.
Okay.
I'll give up and say my other successors who will join me, they'll take up the issue and answer your question. But the issue which I am satisfied, I'll answer. But if submission was 21,
my submission, let's see, my submission is different. I heard Mr. Krishnan Venugopal, for example, say on the first day, he canvassed a position that this is in list 1. Now, I don't want to dilute that submission, but instead of fielding 10 questions from you on list 1 or list 2, I am making the concession straight away to save time. And I am saying, look, I'll please locate it in list 3 as far as entry 17 is concerned. So at least that is Mr. Venugopal's problem, not mine, as to how to persuade your lordships to that point. I mean, I'm just giving. Yeah. Yes, so but I agree with what Mr. Justice Rastogi has observed. Namely, I am trying to put forward my best case. And at least on my limited understanding, these are the points which I thought I may be able to persuade your lordships to.
Worst case scenario for you. So
Sorry?
You're saying that take the worst case scenario.
Right.
Leave out 21, leave out personhood, leave out.
Yeah, narrow it. I'm narrowing it for my.
Within that narrow, you are going to score the point that you.
Hopefully. Now, I'm going to read a few quick paragraphs. I mean, there are several paragraphs, but I want to read them. And please keep this in mind. It's a factual. Now, my lords, I'll just mention. The court, at least my understanding of your lordship's judgment, sitting in panels of constitution benches, is that where cases are decided, founded on facts, then it has a certain repercussion on what the legislature can do and cannot do. And equally, it has a repercussion on what this court can or cannot do when sitting in a larger combination. Just keep that in mind. Why am I emphasizing the factual determinations? The reason is that if it is some pure issue of law, it never is a pure issue of law in that sense. But if there's some statutory provision which is interpreted per incuriam, someone didn't look at some statute which was there, some law was repealed and it was pronounced on, then subsequent benches sitting in larger combinations take a particular view. But where cases are determined on facts, I would try and urge your lordships is probably a narrower focus and compass insofar as revisiting the correctness of an earlier decision. I'm not suggesting you can't do it, but perhaps the yardstick which you will apply may be a little different if you are satisfied that, look, the earlier court looked at the facts threadbare and decided on fact. So this is the background. All right. So, Malaj, please go to page 559 of the judgment. Now, I'll go quite quickly. I have a list here before me of the paragraphs which Mr. Luthra had cited. So I'm going to try and avoid those, but there are a number of ones which we will like to. So this is the first judgment. It is 2014 7 SCC 547. So please go directly to 559.
Yeah.
Now, the opening paragraph itself, Lords, clearly frames the issue which arises here. We are in these cases concerned with an issue of seminal importance with regard to the rights of animals under our constitution, laws, culture, tradition, religion, and ethology, which we have to examine in connection with the conduct of Jallikattu, bullock cart races, etc. in Tamil Nadu and Maharashtra, more particularly with reference to so and so, so and so, so and so. Then it narrates these things, etc. Now, please see paragraph 3. This is a little important for my purpose because this is also an expression which Mr. Luthra had used. Look at para 3. ABWI, a statutory board established under Section 4 of the Prevention of Cruelty to Animals Act, for the promotion of animal welfare and for the purpose of protecting the animals from being subjected to unnecessary pain or suffering, has taken up a specific stand that Jallikattu, bullock cart races, etc., as such, conducted in the states of Tamil Nadu and Maharashtra, respectively, inherently violate the provisions of the PCA. So that was just a stand. We will be guided by the judicial determination. But my submission is going to be that after examining the facts, they came to the conclusion that this is inherently cruel, inherently brutal. Now, please skip the next several pages and kindly go straight away to page 562. Now, paragraph, just above paragraph 16. Bull's behavioral ethology. Ethology, I discovered, is the science of animal behavior. Now, they look at the science of animal behavior. Para 16 is very important. Bulls, so and so, are herbivores by nature. Now, just see this. Adopted to adopted, I think it should be to protect themselves when threatened, engaging in a flight response. That is runaway stimulus when threatening. Bulls in the process use their horns, legs, brute force to protect themselves from threat or harm. Bulls are often considered to be herd animals. Bulls move in a relaxed manner if they are within a herd or even within the bull, with other bulls. Individual bulls exhibit immense anxiety if it is sorted away from the herd. Bulls vocalize when they are forced away from the rest of the herd, and vocalization is an indicator of stress. Bulls exhibit a fight or flight response when exposed to a perceived threat. Bulls are more likely to flee than fight, and in most cases, they fight when agitated. So the court actually looks at this later on as well. Now, please go straight away to paragraph 18 on page 563 about the fifth or the sixth. I'll read the whole. Bulls, as already indicated, according to animal behavior studies, adopt fight or flight when they are frightened or threatened, and the instinctual response to a perceived threat is what is being exploited in Jallikattu or bullock cart races. During Jallikattu, many animals are observed to engage in a flight response as they try to run away from the arena when they experience fear or pain, but cannot do this since the area is completely enclosed. Jallikattu demonstrates a link between actions of humans and the fear, distress, and pain experienced by bulls. Studies indicate that rough or abusive handling of bulls compromises welfare, and for increasing bulls' fear often, now please note this, they are pushed, hit, prodded, abused, causing mental as well as physical harm. Then there is a full detailed description of Jallikattu in paragraphs 19, and paragraph 20 also goes into, now this is important, I'm going to only read some highlighted portions. So let me just indicate what is happening. In para 20 and 21 onwards, over the next several pages, there are detailed abstracts of fact-finding on the basis of what the Animal Welfare Board of India found. I'm going to just highlight some of it. And let me just tell you, in anticipation of your Lordship's question, that we have, after the 2017 report, placed reports in this court, of which I will refer to the most recent one on affidavit, the 2022 report, where the same situation is continuing. Now, just see the executive summary, which begins over here. Now, I'm just, executive summary is the bottom of 563. Now, please go, so this is Animal Welfare Board, what they stated on affidavit in that case. Now, under 564, please go and see Roman 2, welfare implications and violations of the law. Ear cutting and mutilation. At least 80% of the bulls are observed had their ears cut with 3/4 of the external ear pinna absent. When asked about the reason for the mutilation, many bull owners explained that by cutting the ear, the animals would be able to hear sounds even from the back, when they, which were deemed to be very important when the animals are in a Jallikattu arena. Now, see the welfare concerns. Cutting the external ear in no way helps improve the bull's hearing. Instead, the bull loses its natural ability to receive sound signals with appropriate positioning and movement of the ear pinna. Cutting the ear causes intense pain and distress, as the external ear pinna consists of cartilage and is highly vascular with a rich nerve supply. The procedure leads to all sorts of, your Lordships will see, painful past experience. And then the violation is mentioned, which I'm going to skip. Look at 2, fracture and dislocation of tail bones. Many bones suffered from dislocated and even amputated tails caused by deliberate pulling and twisting. The welfare concerns are mentioned. The violation is mentioned. Please go to serial number 3 at page 565. Now, this is important. Frequent defecation and urination. 95% of the bulls were soiled with feces from below the base of their tails and across the majority of their hindquarters. Welfare concerns are mentioned. Please go to Roman 3. Then there's injuries and death under 4. Because of the absence of contained collation area in Avanipuram, a bull died after a head-on collision with a moving passenger bus, etc., etc. Terrified bull sustained injuries, etc. Now, Roman 3, cruel practices in violations of the law, biting a bull's tail. Now, just have a look. This continues. Then please see the bottom of page 566, last line. So that cutting of the tails, etc. As they look at the last. Using irritants. Irritant solutions were rubbed into the eyes and noses of the bulls inside the, I don't know how to pronounce this, vassal, in order to agitate them. And then the welfare concerns, etc. are mentioned. Please see plus item D on page 567. Pulling or twisting the nose rope exerts pressure on the nerve-rich and extremely sensitive septum, causing bulls pain and making it easier for the handlers to force them to move in the desired direction. According to one study, 47% of the animals whose noses were pierced had lacerations and ulcerations, and 56% had pus in their nostrils. The study also pointed out that 50% of the cattle had extensive and severe nose injuries. Now, Lords, this continues. Then there is a heading of bulls made to move sideways. That's at page 568. Lack of food and water is flagged by the Animal Welfare Board of India at serial number 8 on page 568. Then please see 9, forcing bulls to drink liquids. On many occasions, bulls were forced to drink fluids and were likely liquor. Animals' heads were raised by pulling on the nose ropes, and the fluids were forced into their mouths using plastic bottles. The obvious welfare concerns are mentioned. Serial number 10, forcing bulls to stand in their own waste. Then spectators beating and agitating bulls is flagged at in para 11 on page 569. Now please see injuries and deaths, which is the main heading at page 570.
Before you
Yes, sorry. Yes.
It's important that we flag this.
Yes.
So these things apparently entered into the consideration of the court when it tried.
Yeah, absolutely.
Now, if all these things have been adequately redressed,
They haven't.
taken care of in the rules.
No, they're not. I've got my reports.
We are saying
Yeah.
as to whether on the ground it's being done.
So let me just answer the question. Let me answer the question at two. First, in matters such as this, your lordships will see the effect of the law. You may have some great rule, but ultimately, if the material on the record before this court says that it has no effect. Second, and more important for my purposes, the 2009 Act, which is under challenge here, keep the issue alive, had detailed provisions and responsibilities on the collector, which is noted by this court, which they set it out also, that the collector had to do X and had to do Y and had to look over here and look after that. Despite all those, 2009, when this case is rendered, decision is rendered in 2014, what your lordships has is breach, etc., of these rules. So the point I'm making is twofold. I'm sorry. Yeah.
Difference is there.
Yeah.
That is why in the very beginning we put it to Siddharth also.
Yeah.
That we have to lay the 2009 Act and the safeguard there and
Yeah, we'll do that.
side by side.
Yes.
And find out if there is a complete change brought about, number one.
Yeah,
But
but
as to whether on the ground,
yeah,
these rules are being actually observed in the breach or in their observance,
right.
it's a different matter. The impact we'll have to see.
No, but it has made no difference because it's being practiced. You see, there can't be a smoke screen over here. There ought not to be, at least, a smoke screen over here where you reenact the same thing. Instead of the collector, you have some couple of vets which go here and there or supposedly go over there. But on the ground, if the situation, just as you have the Animal Welfare Board reports, which are, look at the part which I have now, which I have reached just now at page 570, it goes district or town after town after town after town. I'm not going to read all those, but I'm going to just show you the headings. They found this across the board, across the state. And that's exactly the same thing which we have found after 2017, in 2018, in 2019, and in 2022, which is what I'm going to refer to. So there's no difference on the ground at all. So it's nothing but a smoke screen which is being put over here to try and say that, oh, now we've got a new law and therefore the whole, everything is hunky-dory and don't worry, etc. about it. But ultimately what we are going to hope to satisfy the court is, if it is inherently cruel, you see, the point is, if this activity is so inherently cruel, having regard to, let's going back to your lordship, the physiology or the body structure of the bulls, etc., what it's meant, it is important. I think that was an important question. Having regard to that, if the court has come to a conclusion that it is inherently cruel, then in our respectful submission, as far as the legislature is concerned, it cannot undo this at all. Because our separation of powers doctrine is very strong that you cannot even deem it. You may earlier, before a judgment of this court, deem X to be Y and Y to be Z. But once there is a judgment of this court, our constitution bench has held, sorry, this is now the realm of the judiciary. We have made a determination, no question of the legislature saying that we are going to change. You can change the basis that your lordships are familiar with, but here what we are going to show is Jallikattu remains Jallikattu. The way it was practiced then continues to be practiced now, and because it is inherently brutal and cruel, as recognized by this judgment, we will urge your lordships to protect this judgment. And it's not as if it ends with this judgment. They had a full-fledged review. They had a hearing on review where they challenged the facts. This is very important. And this court rejected the reopening on facts by a detailed speaking order. So after that, what I'm going to suggest to the court is that the only recourse under our system, or at least under the architecture of the constitution as we understand it, is probably a curative on these facts. on these facts in this. There may be other types of situations, etc. So anyway, let me not now just come back. So you have injuries and deaths. Your lordships will just see this was the question, the 21 aspect which the court is very alive to at the bottom of page 570. Jallikattu is dangerous not only for the bulls but also for humans. Many participants and spectators sustained serious injuries at all the 3 Jallikattu events. A total of 58 participants and 56 spectators were injured at the 3 Jallikattu events. One police constable was also injured at Avaniyapuram. Now, my lords, then there are conclusions, etc. Just see the conclusion. Now, this is in the earlier case at page 571. Bulls are prey animals. The animal behavioral studies, bulls adopt flight or fight response. This instinctual response to be perceived threat is deliberately exploited by Jallikattu organizers. During Jallikattu, many animals are observed to engage in the flight response as they run away from the people when they are experiencing pain or fear. The flight response is not surprising given the amount of pain and terror bulls are subjected to before and during the Jallikattu. Bulls are beaten, poked, prodded, harassed and jumped on by numerous people. They have their tails bitten and twisted and their eyes and noses filled with irritating chemicals. Many peer-reviewed papers demonstrate a link between the actions of humans and the fear, distress and pain experienced by animals. Research has shown that rough and abusive handling of animals compromises welfare by increasing the animal's fear of humans. Bulls who are pushed, hit, prodded, abused in Jallikattu suffer mentally as well as physically. Now, I won't read the rest of it, but just note, sorry.
That is not a conclusion by the court.
No, this is not. The consideration comes later. This is the factual basis. And now just see the heading, detailed reports of Jallikattu at so-and-so, so-and-so, so-and-so. So the next several pages I'm going to skip because these are same things found elsewhere at other locations, etc. Then please go to page 578. I'm not immediately concerned with this but the court focuses its attention on bullock cart races in Maharashtra, just above paragraph 25. Now, to answer just your lordship's question, judicial evaluation, where does that begin? Because your lordship is absolutely right. These were not findings by the court. Judicial evaluation begins at paragraph 33 on page 581, which paragraph 31, 32 and 33, right till 36, Mr. Luthra had read. So I am not going to trouble your lordship. But this is just to point out, to answer your question, this is where the judicial evaluation really begins. With your permission, I am skipping all the paragraphs all the way up to 37. And 37 then is cruelty to animals. And it sets out the various statutory provisions. Then there is a discussion regarding the doctrine of necessity. Then it goes to paragraph 43, which is performing animals. I'm going to skip that with your permission. And para 44, I think this may not have been read because at least my notes show that Mr. Luthra ended at 43. Just look at para 44 on page 586. Bulls, therefore, in our view, now this is the determination, in our view, cannot be performing animals, anatomically not designed for that, but are forced to perform, inflicting pain and suffering in total violation of 3 and 11(1) of the PCA. Now, just let me pause here for a moment. So, your lordship have the first sentence in para 40. So, this is independent reasoning to strike down the action, nothing to do with legislative competence or any of that, or as to whether there is a conflict with the central law. Bulls, therefore, in our view, cannot be performing animals, anatomically not designed for that, but are forced to perform, inflicting pain and suffering in total violation of section 3 and section 11(1) of the Prevention of Cruelty Act. Chapter 5, etc. deals with it. Now, please go. I'm just skipping again a set of paragraphs which were dealt with by.
Would the court have made the same observation?
Yeah.
If the amended provision of section 3,
Absolutely.
because then there is no legally.
Sorry.
Legally, there cannot be a violation if the act doesn't apply. But therefore, in our view, cannot be performing, actually not, but are forced to inflicting pain in violation of section 3 and section 11(1).
That's the Parent Act.
That's Parent Act.
Yeah.
That Parent Act is now amended. We are
Yes.
not considering the Parent Act.
Right.
I told you.
Right.
That if it were considering the Act, Parent Act, as amended by the Tamil Nadu Act.
Yeah.
The Tamil Nadu Act.
Right.
3(1) itself takes it out. 11(1).
Correct. So let me answer that. So the question is that suppose. So let's just look at the case a little differently. which is not what I commend the court to look at it, but we must look at it because let's look at it, examine it from every aspect. If this court were considering the 2017 Act itself, the question being put, or at least as I understand it, is 2017 Act. They're not looking at the 2009 Act at all. Then would this particular discussion and debate, etc., have come up? The answer is yes. And the answer is yes because we would have pointed out that, look, this is what the Animal Welfare Board says. These are the reports and the fact-finding on the ground. In this backdrop, this being inherently cruel, there's no question of a carve-out or an exception, such as is being sought to be done in the Parent Act by this amendment. So the question is, would the issue have arisen? The answer is yes, the issue would have arisen. So, Melod, sorry, if I understand it correct, let us drop the 2009 Act. Let us say that this very 2017 amendment came in the year 2009. An amendment directly to the Parent Act, not through this route of a state legislation. I think that's an important way of looking at it. My answer is, it would have met the same fate. Why do I say that? For all the very reasons, including the judicial determination. Now I'm not on separation of power, etc. I am on the basic point that keep all those technicalities aside, this judgment ought to have or would have come down in our favor in any case. Why? Because the factual foundation was so powerful that this is the manner in which the 2017 Act is still resulting in abuse of cruelty, etc. And you cannot have an amendment in a law for prevention of cruelty to animals which results or enables inherently cruel activity to continue. Inherently cruel activity. Yes.
We take that as your argument.
That is the argument.
And slightly, change the facts.
Yes, let's change the facts.
There is a challenge to the killing of animals for the purpose of preparing food.
Yes.
The answer is,
yes.
It is protected because even though it's a law dealing with cruelty to animals, prevention of cruelty to animals, Section 11(3)(e), to be specific, accepts out of the purview of the Act.
Yes, you're right.
Activities relating to preparing food of any animal.
Yes. With a caveat.
No, what you're saying is, killing the animal is the worst kind of cruelty you can do to it.
Now that jurisprudential. Now let me answer that. Jurisprudentially, both as far as human rights and animal rights is concerned, the approach globally is separate. To what? To killing or taking life, as your lordship correctly puts to me, and cruel. So, for example, in the Universal Declaration for Human Rights, nothing to do with animals, there is a separate clause on cruel and unusual treatment and a separate clause on right to life. Please keep that in mind. There's a distinction between. So, therefore, this court has held. Just now, I'm building on this point. There's a distinction between. So, the court gives you and upholds a death sentence all the way up to this court. So now it's over. Presidential saying all that is closed. Even so, there's an obligation. So your right to life is extinguished now. I mean, in the sense you don't have a legal right to continue because the highest court of the land has said that has affirmed.
Except in accordance with the procedure established by law.
Yes. So I'm not on that aspect. But what this court has held is that even after that stage, as far as treating a person inhumanly or cruelly, because we are drawing a distinction, your lordship is correctly putting to me that, look, if death is sanctioned, then where's the question of cruelty not being sanctioned in some, or not quite as crudely as I'm putting it, your lordships are far more subtle. But the point is that, look, if death is being sanctioned in some situations, then isn't cruel and brutal treatment something lesser? I am seeking to respond to that by saying that there are two separate judicial foundations or planks on which these arguments rest, both for human beings as well as animals. So now let me just complete that thought which I was putting across. So even after death sentences have been upheld, what this court has held is that it's cruel and inhuman treatment if you keep a person on death row for 10 years. That's cruel and inhuman treatment. Please just imagine. He has no right to live under our system, etc., because it's been sanctioned. But you still cannot treat him cruelly or unusually. So not that the death warrant has to be executed in a particular manner and you can't use a cruel and unusual treatment while putting a person to death. That of course you can't do. But apart from that, you cannot, just because his right has been taken away or his right to continue to live has been extinguished through a process of law. So this is what even the United Nations, I mean, I mentioned it, the Universal Declaration of Rights. Equally, it applies to animals. This is now the second point. For animals also, as far as death is concerned, in terms of killing an animal, say for eating or whatever your other, there may be certain situations which have to be looked at distinctly, because as we will see from this judgment, the march of the law and humanism and compassion, which are constitutional values, etc., are such that when the animal is alive, you can't treat that particular person, the animal, in a cruel or unusual manner. I hope I made myself clear. There are two very, very distinct compartments. Obviously, Manoj, at a level, this is how I would suggest the law looks at it. Obviously, Manoj, in a casual conversation, taking someone's life is much worse than treating a person to cruel. I accept that.
No,
But, sorry.
sometimes, say, herbivorous animal is exposed to more violent and carnivorous animal in the forest.
You're right. That's a natural manner in which it plays out.
But
right.
sometimes they are engineered to be in that forest to be
Absolutely.
food of
Oh, absolutely.
carnivores.
Yeah. This act will not extend to such situations at all. Not at all.
No, this act directly would not. But suppose
it's a question of human compassion.
Suppose man,
correct.
to an human agency,
right?
These herbivores are put into a forest,
right,
to be consumed ultimately by carnivore.
Right, right.
Now, would not that amount to cruelty?
Now, look, let me just respond.
We are thinking because...
So frankly, I haven't thought of it that deeply, but I think with these cheetahs arriving in Kuno, they may have to requirement to prepare.
We are not referring to any.
Yeah, but there may be a necessity if a predator is being rehoused somewhere, or you may have a requirement to expand the prey base. Frankly, I haven't thought of, about introduction of prey to expand the prey base for a predator, whether that falls foul of this. But I'll reflect on it and I will respond to your lordship. But I don't think this has a direct application. I think the question is very pertinent on a larger philosophical level. But I think what we are dealing with here in this case is a very real situation.
Not an extreme situation, but
no, I agree with you.
Not an unreal situation.
No, it's not an unreal situation. It may or may not. I will have to reflect on that as to whether it is this thing. But my preliminary response is that when the Prevention of Cruelty to Animals Act is at the intersection of human beings and animals. Yeah. It's at the intersection of human beings and animals. It is not at the intersection of animals and animals. I mean, that's just in terms of an approach.
Shyam, please read
this
from Shyam.
Yes, Sam. Yes.
You're talking juridically about legal rights.
Yeah.
How it has been viewed by the author and what...
Yeah, read it. I'll just read it.
Yes, the portion which you have underlined.
Yes, I will. This is, Manoj, at page 40, this is at page 219 of Salmon on Jurisprudence, and it's the 12th edition. It is to be noticed that in order that an interest should become the subject of a legal right, it must obtain not merely legal protection, but also legal recognition. The interests of beasts are to some extent protected by the law, inasmuch as cruelty to animals is a criminal offense. But beasts are not for this reason possessed of legal rights. The duty of humanity so enforced is not conceived by law as a duty towards beasts, but merely a duty in respect of them. He who ill-treats a child violates a duty which he owes to the child and a right which is vested in him. But he who ill-treats a dog breaks no vinculum juris between him and it, for there is no bond of legal obligation between them. Similarly, a man's interest may obtain legal protection as against himself, as when drunkenness or suicide is made a crime. But he has not for this reason a legal right against himself. The duty to refrain from drunkenness is not conceived by the law as a duty owing by a man to himself, but one which is owing by him to the community. And then further down the underlined portion is, there's nothing in the nature of things to prevent a legal system from regarding right as inhering in animals or idols. And in fact, some Eastern systems do regard rights as inhering in idols. Rights may also be bestowed by the law on artificial persons such as corporations. Yet in both these cases,
next page also.
Yes.
Next page also. Legal. What are the requirements of a legal right?
Yes, the characterizations of legal. Every legal right has the 5 following characteristics. Is vested in a person who may be distinguished as the owner.
Therefore,
it avails against the person.
The owner of the right.
Yeah.
Because every
Right.
legal right.
Yes. Thank you for this.
Yes.
Just remember.
Because we have to proceed.
Yeah.
When you're examining animal rights, when
Yeah.
you're saying, we're talking
Yeah.
about animal rights.
No, we're not
Talking about,
talking.
talking about animal rights here.
No, I'm not talking. I'll come to that later. So far, I'm not talking about animal rights at all. I am.
Are you saying that animals don't have rights?
No, I am not. Because animals have rights in the form they have. For my purposes, let me make it very, very clear. I am not suggesting for a moment that animals have constitutional rights on our present status and understanding of the law.
Legal rights.
As far as legal rights are concerned, as Nagaraj says, they are a mirror image of obligations of individuals and the state. So that's one element. That's the language used. There are rights and duties. There are, as the Nagaraj judgment says, there are duties cast, say, on the owner. There is a corresponding reflection that may be termed under some certain jurisprudential principles as a right not to be treated cruelly. That's one. But I am not going that far. I am saying that the structure of the law as we understand it requires and imposes duties on individuals, and it imposes a duty on the state, which involves elements of compassion to animals, etc. In that context, you as the state has a constitutional obligation to ensure that it doesn't visit bulls with cruelty. So this is one part of the argument, but I must complete the second part.
You are not relying on para 66 of A Nagaraja?
No, I am relying on 66.
Please read para 66 then.
Yes. 66 is the
rights guaranteed to animals under section 311, etc. are only.
Yes, so this rights guaranteed. So just
how they could be elevated to the status of a fundamental rights, that was the consideration.
No, sorry, that's not how this judgment ought to be read. Now let me just answer it.
That's why para 66, that is the starting point. We just read that.
No, the starting point is before 66, but I'll read 66.
66, the way.
Rights guaranteed to animals under sections 311, etc. are only statutory rights. The same have to be elevated to the status of fundamental rights, as has been done in a few countries around the world, so as to secure their honor and dignity. Rights and freedoms guaranteed to animals under sections 3 and 11 have to be read along with 51A(g) and H of the Constitution, which is the Magna Carta of animal rights. So now let me answer this question. Now, let me just complete the answer, and it's in answer to Justice Ravi Kumar. Yes, I'll just come to that. So there are two elements. Now, we are just on this notion of animal rights. So I'm only on that for the moment, then I'll pick up the thread where we left it. As far as animal rights is concerned, they arise in two manners, two ways. The expression animal rights as used in this judgment and as understood globally is in two contexts. What are those two contexts? One, for our purposes, is a reflection of the duty cast on humans. That's one. So if there's a duty cast on humans, this court has interpreted it, the law, to be a corresponding right to animals to that limited extent. It's a limited right. The other are, what I indicated earlier, 5 freedoms which are held universally in the jurisprudence to be a foundation of compassion to animals. So one of the freedoms, for example, is that, and I'm just using an expression, thermal comfort. So you can't put an animal in something which is so cold that it is miserable all that. I'm just saying cold just now. You can't put equally an animal which is accustomed to a cold environment in something which is very, very hot. This is not a right which your lordships find in Prevention of Cruelty, but it's an act it's a right which is derived, and it is derived from the fact that this right to thermal comfort is one of the 5 freedoms which is recognized in the context of animals, particularly sentient animals, which are dealt with. So para 66 is very important. We are very much depending on 66, but it's in the context of the earlier paragraphs which I'm about to read. Then we will have a fuller and a more complete understanding. So, my lords, please see para 44 I read. Now just please go if your lordships would, to straight away, just have a look at paragraph 53. Now, this I'm not going to read because I believe, at least my notes show that Mr. Luthra read 53 as well as 54. But front and center, this court looked at culture and tradition. Because please see the statement and objects of the 2009 Act. The statement of objects of the 2009 Act refers to an ancient culture and tradition and does not state that it has any religious significance. Even the ancient culture and tradition do not support the conduct of Jallikattu or bullock cart race in the form in which they are being conducted at present, and it goes on. So these are factual determinations which are based on the basis of the material which is before them. Now please see, very important in answering this question, international approach to animal welfare, which begins at 590, page 590. So first they talk about the first stage, human self-interest reason for environmental protection. So they explain the various global treaties in the 17th, 18th century, etc. Then the second stage talks about international equity. This stage saw the extension of treaties beyond the requirements of the present generation, so also to meet future generations of human beings. This shift is signaled in a departure from the pure tenets of anthropocentrism. For example, then they talk about the Whaling Convention, etc. And then it goes to the third stage, nature's own rights. Recent multinational instruments have asserted the intrinsic value of nature. It refers to the UNEP Biodiversity Convention of 1992. It mentions several cases in paragraph 58. And then please have a look, if your lordships would, to paragraph 59. Based on ecocentric principles, rights of animals have been recognized in various countries. Protection of animals has been guaranteed by the Constitution of Germany by way of an amendment in 2002, when the words "and the animals" were added to the constitutional clauses that obliges the state to respect animal dignity. Therefore, the dignity of animals is constitutionally recognized in that country. German animal welfare law, especially Article 3, provides for far-reaching protection to animals, including inter alia from animal fights and other activities that may result in pain, suffering, and harm for the animals. Countries like Switzerland, Austria, Slovenia have enacted legislation to include animal welfare in their national constitutions so as to balance the animal owner's fundamental rights to property and the animal's interests in freedom from unnecessary suffering or pain, damage, and fear. Then there's a reference to the Animal Welfare Act of 2006 in the UK. With your permission, my lords, I'm going to skip that. And then please see para 62. The Universal Declaration of Animal Welfare, UDO, is a campaign led by the World Society for the Protection of Animals, WSPA, in an attempt to secure international recognition for the principles of animal welfare. UDO has considerable support from various countries, including India. So and so believes that we should look at the success of the Universal Declaration of Human Rights as set out that UDO can achieve for animals. 5 freedoms referred to in UDO, which we will deal with later in this judgment, find support in the Prevention of Cruelty Act and the rules framed thereunder to a great extent. So now this is the important part. Now see the next paragraph. World Health Organization, of which India is a member, acts as the international reference organization for animal health and animal welfare. OIE has been recognized as a reference organization for WTO, and in the year 2013, it had a total of 178 countries. On animal welfare, OIE says that animal is a good state of welfare if it is healthy, comfortable, well-nourished, etc., able to express innate behavior as it is not suffering from unpleasant states such as pain, fear, and distress. Chapter 7.1.2, Guidelines of OIE recognize 5 internationally recognized freedoms for animals such as 1. Freedom from hunger, thirst, and malnutrition. 2. Freedom from fear and distress. 3. Freedom from physical and thermal discomfort. 4. Freedom from pain, injury, and disease. And 5. Freedom from to express normal patterns of behavior. Food Agriculture Organization, in its legislative and regulatory options, etc., indicated that these 5 freedoms found their place in the Farm Welfare Council 2009 of UK and also called the Bramwell's 5 freedoms. These 5 freedoms, as already indicated, are considered to be the fundamental principles of animal welfare And we can say that these freedoms find place in sections 3 and 11 of the Prevention of Cruelty Act, and therefore animals like the rights guaranteed to citizens in this country under Part 3. So this is the context. Now I am mobilized for your Lordship's observation. 66. Rights guaranteed. So in this context, your Lordships will see 5 freedoms, mirror, reflection and duty. 66. Rights guaranteed to the animals under 311, etc. are only statutory rights. The same have to be elevated to the status of fundamental rights, etc. as done by a few countries. Rights and freedoms guaranteed to the animals under section 3 and 11 have to be read along with articles 51A, G and H of the Constitution, which is the Magna Carta of animal rights. Then it goes into the whole value of compassion, which is very important. It looks at humanism, which is a very important feature. Then I think I'm just seeing, yes, Mr. Luthra read paragraph 71. So I'm not reading para 71, but please see, now this is the right to life discussion at 72. And just have a look at para 73. Jallikattu and other forms of bull races, I'm on page 596. As the various reports indicate, cause considerable pain, stress. Now this is a determination by the court. This is not just some report. Cause considerable pain, stress and strain on the bulls. Bull in such events do not, not only do move their head, showing that they do not want to go to the arena, but as pain is inflicted in the varivassal is so much that they have no other go but to flee to a situation which is adverse to them. Bulls in that situation are stressed, exhausted, injured, and humiliated. Frustration of the bulls is noticeable in their vocalization. And looking at the facial expressions of the bulls, ethologists or an ordinary man can easily sense their suffering. Bulls otherwise are very peaceful animals dedicating their life for human use and requirement, but they are subjected to such an ordeal that not only inflicts serious suffering and injury to behave in ways, namely that they do not have, force them into the event which does not like, and in that process, they are being tortured to the hilt. Bulls cannot carry the so-called performance without being exhausted, injured, tortured, or humiliated. Bulls are also intentionally subjected to fear, injury, both mentally and physically, and put to unnecessary stress and strain for human pleasure and enjoyment, and that too, a species which is totally dedicated its life for human benefit. We are therefore of the view that sections 21 and 22 of the Prevention of Cruelty Act and the relevant provisions have to be understood in the light of the rights conferred on animals under section 3, read with sections 11(1)(a) and O and articles 51A, G and H of the Constitution. And if so read, in our view, bulls cannot be used as performing animals for Jallikattu and bullock cart race, since they are basically draft and pack animals, not anatomically designed for such performance. So this is the point. Now, repugnancy comes later on. So, on a foundational fact of what the court was fully and completely satisfied with, they found that this is inherently, Jallikattu is inherently cruel, treatment being meted out to these bulls, and therefore it can't. Obviously, the next part I'm not required to read because it's on the repugnancy argument, and then the conclusions have already been read to your lordships. On this aspect, I'm just mentioning to the court, in 91.9, I started with that. Parliament, it is expected, would elevate the animals to that of constitutional rights as done by many other countries, etc. So I am not claiming that it is already there and lodged in the Constitution. Your Lordship will just give me. If you can. Now, because that done, may I just take you to the judgment? If your Lordships, are you reading this from volume 5, Convenience Compilation, volume 5? Is that where your Lordship has the book?
We have.
Yeah, the book. Then please hand over 2017 to SEC, page 144. Now, let me indicate what happened. What happened was that a review petition was filed by none other than the state of Tamil Nadu, which is the correct constitutional recourse. The correct constitutional recourse is if you are dissatisfied and if you feel
144.
2017 to SEC 144. So this is a judgment rendered on November 16, 2016. Sorry?
This is 60 order.
No, I think this is Justice Deepak Mishra. and Justice Nariman. This is Justice Deepak Mishra. It reads as judgment, but I'm not sure as to who's authored it. But in any case, so let me just sum up what has happened over here and then I'll take you to the paragraphs. So a review was presented, which is the correct constitutional recourse. This is absolutely correct what the state of Tamil Nadu did. They came back to this court and said, you have made errors of fact. Please review the judgment. The court looks at it and rejects it. That's one. And number two, there are certain objections which are raised also on the law in the course of the review. So we have the advantage of a speaking judgment here. It's not just. So please see the judgment itself begins from page 146. It starts narrating that, look, ordinarily reviews are decided on circulation, etc. But here we are looking at it a little closer. And then just have a look at paragraph 2. Now, I might just mention, they exhaustively revisit the sections, etc. I'm not going to read them all, but I'll just read a few paras. So for adjudication of the review petition, certain facts need to be stated on 11th July 2021. So they mentioned, my lords, that performing an notification that, and which says that as far as bears, monkeys, tigers, panthers, lions and bulls are concerned, these are not to be used as performance animals. And then your lordships will see the conclusion in Nagaraja's case is set out in paragraph 4. With your permission, I'm going to skip that entirely. Then please go, if your lordships would, sorry.
25, actually.
I think I can go straight away to that. I want you to just see one other part, because I'm not going to take you to the sections. So just earlier, just have a look at paragraph 14. Paragraph 14 on page 151. Having scanned the anatomy of the PCA Act. Now, they looked at the PCA Act. Then, it's obligatory on our part to refer to the 2009 Act, as Mr. Nafde, learned senior counsel, would urge with emphasis that the purposes of the Act is to regulate Jallikattu in the state, etc. So then they show us the definition. Now look at this, para 50. See, this is important because all the arrangements were already there. This is the point. Section 3 of the 2009 Act treats conducting Jallikattu as an event. Section 4 casts a responsibility on the organizers. Who organizes the event? Section 5 requires the collector of the district to make arrangements. Now, please see the arrangements which are made by the collector, which is under Section 5. Collector shall ensure double barricading, ensure number of spectators in the gallery shall not exceed the time limit, ensure safety certificate is obtained from the public works, ensure that the bulls are free from disease, nicotine, etc. Arrange to provide, not intoxicated and administered with nicotine, cocaine, with the object of making some aggressive and ferocious behavior. Arrange to provide adequate police protection. Arrange to provide adequate medical facilities, which means a vet, ambulance, etc. Arrange that necessary drinking water as well as sanitation facilities in the place where the event is to be held. Authorize an officer not below the rank of deputy collector to look after each item in the event. An arrangement like checking up the bulls, checking up the bull tamers, checking up the barricading, arrangements, medical facilities, water supply, sanitary arrangements, safety of spectators, etc.
Oversimplifying.
Yes, sorry.
Unless you really, go into the details of the rules,
right,
we may not be doing justice to the rules.
Which rules? Present rules.
Yeah.
No, we'll come to the. I'm just on what was there.
This may not be because this is primarily geared
2009 Act.
2009 Act
and collector. Correct.
Relates to the safety of the spectators rather than on the.
No, the animals. I said that nicotine.
The rules now, it is slightly more different.
No. So let me just meet that argument. At least my understanding is, I think this clause here, ensure that the bulls are free of disease and not intoxicated or administered with any substance like nicotine, cocaine, with the object of making them aggressive or ferocious with the assistance of the animal husbandry department.
That is all. But in the rules, there are a completely different scenario is there.
Yes, sanitation facilities, drinking water, etc. I think this is the bull tamers. Look at the next one, Roman 8.
But
so look, I will just
see the rule.
We will see the rules. We will examine the rules. Okay, may I make a suggestion? My point over here is that if this had worked, if the rules or the Section 5 under the 2009 Act had worked, there is no question of any of the findings recorded in the principal judgment in Nagaraj being rendered. So basically what was happening was that despite the
even if it had worked.
Even if it had worked.
Even if it had worked.
Yes.
It would still be
all foul.
found that it is still cruel to the bulls.
That's my argument.
That is correct.
I don't know.
But we're telling you.
Very well.
Take it as it
That's
is.
a step forward for me.
Take it
Yeah.
that it is correct from the court's point of view.
Yes. Right.
We're telling you after that when the rules were made,
Right.
which is what the President Assent is all about.
Hmm.
It is not just Jallikattu, which 311. It is also as a package 311 read with the rules, which is actually put in place.
No, the act, the what received presidential assent is obviously the act, because that is all that receives presidential assent, and the rules are framed under the act. So we will come to that. We'll deal with that as well. But now just see the finding at page 153. So I accept at the moment that look, this is in the context of the earlier set of law.
Right.
You're absolutely right. Now after in para 17, I won't read it, but they reproduce paragraph 73. And then see the plus item D just below the quoted portion on page 153. Thus, the contention that no cruelty is meted out to them while involving them in the event of Jallikattu does not commend acceptation. And it is extremely difficult to hold that the court in its judgment had factually erred. So this is now really, according to me, if we are right, this is the end as far as the state interference. Once there is a factual finding and the review is dismissed, then under hurrah, you may be able to file a curative, but that hasn't happened yet. But that's the end of the road as far as the legislature is concerned as well. Why? As well, legislature as well. Why? Because there is a determination on facts. It has been found to be something which is unconscionable in the sense of cruelty and etc. to the animals and bulls. We're not going generally to animals. On facts. So this is an important line just above paragraph 17. Then the hub of the matter, which is the act in consonance with, now this is the other important aspect. The hub of the matter is whether such an act is in consonance with the prevention of, see, this is the test which will still apply. This will still apply even today, not in the context of legislative competence. I'm not on that. I'm on the context of can you have these two at all standing? And A Nagaraja, the bench notes, they reproduce paragraphs 88, they reproduce paragraph 89. Now just see, go to page 154, second line from the top. Now this is a quote from Nagaraja. Overpowering the performing animal was never in the contemplation of the Prevention of Cruelty Act. And in fact, under section 3, a statutory duty has been cast on the person who is in charge of care of the animal to ensure the well-being of such animal and to prevent infliction on the animal of unnecessary pain and suffering. The PCA therefore casts not only duties on human beings, but also confers corresponding rights on animals. Now, this is exactly what Justice C.T. Ravi Kumar was putting to me. What is this nature of rights? Saman tells us that, look, as we have evolved as a system, we do not give personhood Saman. We do not give, this court of course may evolve it further. But at least as far as Saman's 12th edition is concerned, the nature of animal rights are not in the sense of a right vested in the animal, but a reflection of the duty to not be cruel. That is exactly what is cast here. The PCA therefore casts not only duties on human beings, but also confers corresponding rights on animals, which is being taken away by the state enactment by conferring rights on the organizers and bull tamers to conduct Jallikattu, which is inconsistent and in direct collision with section 3, so-and-so, which is the welfare legislation and hence constitutionally infirm. And then please see, the submissions of so-and-so is that there has been an inappropriate appreciation of the 2009 Act and the principle of repugnancy has been applied in a wholly fallacious manner. It is also put forth that the court has been influenced by international concepts of animal welfare and further erred in referring to the Upanishads, which should not have been referred to. Before adverting to the issue of repugnancy, we think we should deal with the submission that pertains to the reference to the Upanishads and international perception that is sought to be criticized. The court in Nagaraj, in paragraph 55, has translated a few lines from the Isha Upanishad, which reads as follows: the universe, along with its creatures, belongs to the land. No creature is superior to others. Human beings should not be above nature. Let no one species encroach upon the rights and privileges of other species. We do not think the allusion to the Isha Upanishad in the context of animal welfare is alien to the context. The court, we are inclined to think, while dealing with the law and legal principles, can refer to the cultural ethos and the ancient texts of the country insofar as they do not run counter to the constitutional and statutory thought and principle, as far as the international concept is concerned, etc., we are obliged to say that the philosophy of compassion can have manifold articulations. The last line. And then, my lords, it goes into the issue regarding repugnancy. Now, please go directly to page 156, para 26. Mr. Nafte, learned senior counsel, has submitted that the 2009 falls under Schedule 7, Entry 2, List 14 and 15 of the Constitution. Entries 14 and 15 read as under. We really fail to fathom how Entry 14 can remotely can have anything to do with Jallikattu, which is an event solely because the event takes place after the harvest, etc. And then last two lines, thus we unhesitatingly hold that the activity Jallikattu falls squarely within Entry 17 of List 3, and therefore it has to be tested on the anvil of repugnancy, etc. And then the court goes on and rejects the review petitions, as your lordships have noticed. So now, my lords, we have now, where does this take us? Because we have a situation now where we have a full-fledged judgment according to us entirely on facts, and we have. Now there is a useful decision which Mr. Luthra had referred to, except that he didn't read the paragraphs that I am seeking to rely on. There's guidance to be obtained. I'll state the point and then I'll come to the judgment. There is guidance to be obtained from this court's previous judgment sitting in a constitutional bench strength to the effect that where the court has examined an issue on facts, then the legislature has no role left at all. If it's on facts, I have to show, we've endeavored to show your lordships. I will deal with the present situation on facts in a moment. But let me just deal with this judgment, then I'll come straight away to the 2002 report, where to show that things haven't changed at all. Now, please just take up. Now, this judgment is in Mr. Luthra's compilation.
2014-12.
Serial number 31.
Is it 2014-12 SEC?
14-12 SEC 696. Now, let me just indicate what happened here, and then I'll read the paragraph. So, this is State of Tamil Nadu versus Kerala. That's the caption. It's a constitution bench judgment of our court. In Mr. Luthra's list, if your lordship has that compilation, then it's at serial number 31. Otherwise, if you have the book, I'm more comfortable with the book. Now, let me just state the point. Here, there was a determination by the court with regard to what the height of Mullaperiyar Dam could be, should be, after a full contest, etc. And they came up with a certain figure. That was sought to be negatived through a legislative process. The court rejected this or struck this down on many bases. We are, of course, confining ourselves to this principle that if you have a determination made by the court on facts, then can it be reopened by the legislature? The answer we find over here is that you can't. Now, please, therefore, go straight away to the judgment begins at page 717. Your lordships have it. 717. Please go to paragraph 12 on page 719. 719.
You perhaps may not have to labor because it shows a paragraph. I think it's settled law.
Right? No, but I want to show some paragraphs which were not read to the court.
Family onwards.
Yes. Right.
I think it's fairly settled law. It's a matter.
Right.
Powers, the court cannot, legislature cannot simply say, no, that's not the way it is like this. You are usurping the judicial power. Cannot be done.
So that's the general principle. Now I'm on something which is a little narrower. The narrower point which I am making is, it cannot be done on a case founded on facts. Because facts, those bills of attainder on which your lordships have in a panel of two judges reiterated, which I'll come to later on. But just let's see this. Paragraph 12 on page 719.
Actually, it was read to us. It is paragraph 149.
Yes, but I want to read a few other paragraphs. Your lordships have read 149. There's just a few. 114. Yes. So yes. So, my lord, I want to read a few others.
Which paragraph you want to?
First, I want to read 12. 12. After hearing the parties, including the two states, so here again Tamil Nadu and was certainly heard. After hearing the parties, including the two states, this court gave its decision on 27/2/2006, permitting the water level of Mullaperiyar Dam to be raised to 142 feet. The state of Kerala and its officers were also restrained from causing any obstruction to the above. It was also observed that after strengthening work was complete to the satisfaction of CWC, independent experts would examine the safety angle before the water level is permitted to be raised to 152 feet. Now go to paragraph 18, grounds of challenge to the 2006 Amendment Act. I'm just pointing it out. So the various grounds are set out, including the competence, etc. So I'm just pointing this out. I'm not going to read it, but your lordships have noted it. Now please go directly, if your lordships would, to paragraph 155.
Yeah.
On page 786, it is true that the safety of the dam is an aspect which can change from time to time in different circumstances. But then the circumstances have to be shown based on which it became necessary to make a departure from the earlier finding. It's always open for any party to approach the court in applying for reassessing the safety aspect, but absent the change in circumstances, factual determination in the earlier proceedings, even on questions such as safety of dam, binds the parties. If the circumstances have changed, which necessitates a relook on the aspect of safety, the court itself may exercise its discretion to reopen the case. But legislative abrogation of a judgment for even the very best of reasons and genuine concerns for public safety does not clothe the legislature to rescind the judgment of the court by a legislation. The contention of Mr. Salve that by declaring the dam unsafe, the legislature has not rendered any finding of fact. It deems the dam unsafe and sets up an authority to regulate it is noted to be rejected. What has been found as a fact by a judicial determination cannot be declared otherwise by applying legal fiction. We are, however, persuaded to accept the submission of Mr. Vinod Bobde, Learned Senior Counsel for Tamil Nadu, that the fact that the Mullaperiyar Dam is safe was found by this court, and that finding of fact can never be deemed to be imaginary by a legal fiction, which then proceeds to deem the opposite to be real, that is, the dam is in danger. This is not a matter of legislative policy, as it has been made out to be. Rather, in our opinion, it is an incursion in the judicial process and functions of judicial organ. The declaration under section 62A, read with item 1 of the second schedule, leaves no manner of doubt that the enactment is intended to reach the question decided by the court. The question whether or not a legislature has usurped the judicial power or enacted a law in breach of separation of powers principles would depend upon the facts of each case, considering the real effect of the law on a judgment or judicial proceeding. One of the tests for determining whether a judgment is nullified is to see whether the law and the judgment are inconsistent and irreconcilable, so that both cannot stand together. In that we have already discussed above, it is abundantly clear that on the one hand, there is a finding of fact determined by this court on hearing the parties on the basis of evidence and materials placed on the record in the judgment of this court in Mullaperiyar Environmental Protection Forum. And on the other hand is the 2006 Amendment Act. The Kerala legislature has declared the dam being endangered, and fixed the water level in the dam at 136 feet. If the judgment of this court in Mullaperiyar and the 2006 amendment were placed side by side, insofar as safety of the Mullaperiyar Dam as raising the water from 136 to 142 feet is concerned, it is obvious that the judgment of this court and the law enacted by the Kerala state legislature cannot stand together, and they are irreconcilable and inconsistent. The impugned law is a classic case of nullification of a judgment simpliciter. As in the judgment of this court, the questions of safety of the dam was determined on the basis of materials placed before it and not on an interpretation of an existing law, and there was no occasion for the legislature to amend the law by altering the basis on which the judgment was founded. When the impugned law is not a validation law, there's no question of the legislature removing the defect, as the judgment has not found any vice in the existing law and declared such law to be bad. There is yet another facet to the federal disputes. The legislature, parliament and the state legislatures cannot be a judge in their own course in the case of any dispute with another state, the rule of law, etc. With your permission, I may skip that. And then please see paragraph 160. When a dispute between two states has already been adjudicated upon by this court, which is empowered to deal with the unilateral, which it is empowered to deal with, any unilateral law enacted by one of the parties that results in overturning a final judgment is bad, not because it is affected by the principles of res judicata, but because it infringes on the doctrine of separation of powers, the rule of law, and as such law, the legislature has clearly usurped the judicial power. Now, this is very important. Once this court made a determination on facts on the basis of the material and the reports which was before it, then they came back And they said review because your findings of fact were wrong. This court rejected the review. Now, once that happens, no matter how egregious the decision of this court, from a legislative standpoint, you can't come in. There may be other methods of correcting the situation that I have mentioned to your lordships. There may be a curative system or other methods may be available under the, assuming it's wrong. I'm of course saying it is entirely right. But certainly legislation, because this is the end of it. Once facts are determined as to the ethology of the bull, the physical nature of the bull, the cruelty inflicted on the bull, then by having a veterinary surgeon or something like that, and some distancing among spectators is not going to change the finding of fact at all. So the point here is, once you reach a determination, as this court has, that there is an inherent cruelty in Jallikattu, that is the end of the matter as far as the legislature is concerned. Otherwise, it is completely in violation of a very, very fundamental principle of our court. The next decision, I won't cite it. I mean, in the sense, I won't read it. I'll just invite your lordship's attention to it, and then I'll just get back to the facts for a moment. That decision, your lordship may note, is in re. Just give me that second. Yes. No, your lordship may just note the judgment. So this case was followed by another constitution bench in the case titled Punjab Termination of Agreement Act 2004. In re, the citation is 2017 1 SCC 121. As I indicated, it is a constitution bench judgment. The relevant paragraphs are 33 to 37. And essentially what had happened there was that there was a decree of this court. There was a decree of this court, and it said that a certain canal has to be constructed, etc. That was sought to be negated by the Punjab legislature. The President of India made a reference to this court. The reference was answered, and relying upon state of Tamil Nadu versus state of Kerala, this court, again, you relied upon those paragraphs to come to the same conclusion that this is not the realm of the legislature at all. Once there's a judgment of this court, there's no question of undoing it. So I'm not citing it. I'm not playing. I've just given your lordship the citation.
What is the page?
Sorry. Oh, my mistake. Page is 2017 1 SEC, page 121. And the relevant paragraphs are 33 to 37. 39. I'm sorry. My mistake. It's paras 33 to 39. Now, this is on this aspect. Now, I want to just go back. And here, this document is already in the compilation, but we're just going to hand it over because what has been done in the compilation, and I don't blame the persons who prepared it, was that they prepared black and white photographs. I am going to go on the text. We'll come to the photographs later. Now, there are a series of reports which we have placed on affidavit before this court. This is for the period 2017 and later. And we are first going to look at the text. This is all supported by affidavit, and then give it to them. And then we will go to the whole issue regarding what is. So this is now bringing you up to date on facts. So this is now investigations into the Jallikattu events, 14th to 31st January 2022. Please go. You may cast an eye over the table of contents, but I'd be happy if you go to page 3. Please go to page 3 of B1. We will avoid all the photographs at this stage and go to the text. So please go to page 3. So we have now details of the investigation. So this is 2022, correct? January. Jallikattu events investigated. The places are shown. The districts are indicated. And the specific dates of the events are also shown. The objectives of the investigation are outlined: to record the treatment of bulls, to check for violations of animal protection laws and rules, and to record any reported human and bull injuries and casualties. Now look at the executive summary. PETA, India's comprehensive investigation into 7 Jallikattu events, including 3 at so-and-so, Vellore, Tamil Nadu, from 14th to 31st January 2022. Then the Prevention of Cruelty Act, which we mentioned the reference to the rules, etc. Not we. This report mentions it. Now please see the third paragraph. Furthermore, COVID-19 guidelines and restrictions issued by the Tamil Nadu state for Jallikattu were brazenly flouted. More than 300 participants were registered at some of the Jallikattu events, and more than 150 spectators were admitted at the so-and-so events, with the spectator galleries and the arena packed to full instead of 150 spectators or 50% of the state government protocol. The spectators weren't wearing any face masks, etc. With your permission, I'll skip that and go to the last paragraph. This latest eyewitness investigation, as well as the previous investigations of Jallikattu events, confirm that Jallikattu takes advantage of bulls' natural nervousness as prey animals, deliberately placing them in terrifying situations in which they are forced to run away from those they rightly perceive as a threat. The evidence of photographs and video footage shows that during Jallikattu events, bulls are hit, tackled, and poked with wooden sticks, including nail-studded ones, and other sharp objects. Their tails are bitten and twisted, and they are treated in other cruel ways. At the 4 events out of the 7 Jallikattu events investigated in 2022, exhausted and dehydrated animals were forced to participate after being made to stand in queues for several hours without overhead shelter or sufficient water or feed. They were yanked roughly by nose ropes, causing their nostrils to bleed, and many collapsed from exhaustion or dehydration from before and after they ran through the arena. Such abuse led to severe injuries, including broken bones and even death. The following statistics have been compiled based on multiple newspaper articles. In 2022, the number of deaths of both bulls and humans at the event skyrocketed within 4 months. Bull injuries and deaths are not always reported by the media, yet in 2022, between 13 January and 30th April alone, 1655 humans and 6 bulls were reportedly injured, and at least 17 humans and 2 bulls died. In 2021, between the first event in January and April, 25th April, 1,119 humans and 8 bulls were reportedly injured, and at least 14 humans and 1 bull died. In 2020, between January and 9th March 2020, at least 570 humans sustained injuries, and 13 humans and 6 bulls died during Jallikattu events. In 2019, at least 5 bulls and 1 cow reportedly died during Jallikattu events, and at least 8 humans reportedly died, and 597 people sustained injuries. In 2018, at least 6 bulls and 14 humans reportedly died. In 2017, at least 3 bulls and 20 humans reportedly died. According to news reports, the total number of human fatalities resulting from Jallikattu events in the last 7 years, from 2017 to 30th April 2022, is at least 86. In the same period, 6,351 humans were injured, and 23 bulls and a cow reportedly died. As Jallikattu continues, a staggering number of human deaths and injuries continue to occur. Over the years, even after the issuance of the Tamil Nadu PCA Conduct of Jallikattu Rules 2017, there have been a steady increase in reports of bulls' deaths, confirming that no amount of regulation can prevent participants from subjecting them to cruelty and injury. Inspections conducted by the Animal Welfare Board in 11, 12, 13, 14, and by PETA in 17, 18, 19, 20, and 21 have also demonstrated that Jallikattu is inherently cruel, causes bulls unnecessary suffering, and is a direct violation of the provisions of section so-and-so, as held. Now, key observations and finding. Now, there is we'll skip the photographic evidence, so let's skip that. And from page 4, please directly first go to page 69. One step. Go directly to 69. We'll deal with the photographs later on. No, actually, your lordships may go a little earlier, I think, to page 59. No? Please go to 59, 59.
We don't have any pagination.
Sorry?
There is no pagination.
At the foot, at the foot.
Bottom.
Your lordships have bottom left. So I just completed page 4. Now I'm requesting you to go to 59, 59. Now see what was observed. Onlookers and spectators at 7 Jallikattu events were filmed pouncing on and illegally tackling bulls fleeing in the bull run areas or arena. The same illegal practice was observed and filmed inside and outside the collection yards, where boisterous spectators jumped onto bulls and held onto their humps. This illegal practice was particularly rampant in the Jallikattu events at Avniyapuram, Palamedu, so-and-so, so-and-so. Parallel Jallikattu causes additional physical injuries and mental trauma to the frightened bulls. While PETA India does not support even registered participants tackling bulls in Jallikattu, illegal tackling by onlookers mocks the registered participants who undergo the compulsory protocol of registering, which includes undergoing a physical examination by a doctor, presenting a COVID-19 vaccination certificate indicating 2 doses and a negative RT-PCR test result taken 2 days before the event. While the participants were brought into the arena in batches and given a stipulated time frame to participate, several onlookers and spectators outside the collection yards illegally engaged in pouncing on and tackling the fleeing bulls throughout the duration of the event. Then please go to page 61, the page being at the foot. COVID-19 rules brazenly flouted. So with your permission, I'm going to skip that. Please see, your lordships may then go, just see the headings, please. On page 62, restrictions on number of participants violated. The other heading on page 62 is maximum spectator limit of 150 persons and 50% arena capacity rule violated. Then there was some no distancing, etc. Please go directly to page 73. Sorry? 71. So, all right, 71, my mistake, 71. Yes, so I'm just going to read the headings. Actually, you may go one page back, page 70. Jallikattu events not held in open grounds. So this is some rule 2017 violated. We have given the full details over here in this report. On page 70, the organizers shall conduct Jallikattu in an open ground. Furthermore, GO says so-and-so, so-and-so. In Avaniyapuram, Jallikattu was held in the middle of the village in streets cordoned off by police and district administration authorities. So-and-so Jallikattu was held in the town center and its narrow bylanes, the arena erected by a bylane had a curved path, not a straight one, etc., etc. Bulls were observed and filmed skidding and falling to the ground in the so-and-so event, and so-and-so as a bull run area had a 90-degree turn. Then insufficient or no feed, drinking water or shelter. That's the heading at page 71, and the details are provided for in the text over there. Now, legal violations, we have set out at, I won't be reading this, paragraph 73 onwards. I'm sorry, my mistake, page 73. Page 73, there's a heading on legal violations. So this is on the understanding that these rules are in force, etc. This is what the observers and those who prepared this report found. So open ground is violated. The caption says violations at the 3 events investigated. Then bulls shall be provided rest for a minimum of 20 minutes. This was not implemented at any of the events. Many bulls were brought the night before the event, forced to stand in a queue overnight, were made to wait for up to 16 hours. The whole idea, let me just tell you, what Justice Radhakrishnan found in the first judgment was that the idea is to enrage and provoke the animal. It is, and for that your lordship saw there's chili used in the nostrils, liquor in all sorts of orifices, etc., prodding, cruel treatment, and the animal is provoked, and then there is some sort of a contest on some understanding, I don't think cultural, but some machoism or something like that, and you try and mount on the bull and you hold him by the hump and whatever, you tame the bull. Tame the bull is a sort of a mild expression which I'm using. So there's physical violence and mental violence. What this report appears to suggest is, this is for 1 year, 2022. I'm obviously not going to burden, I mean, the court is already burdened in terms of the record with reports on 2018, 2019, 20 and 21. I won't be taking your lordships through those, but they are in a similar vein, where the activists, etc., actually went to the ground and examined for themselves as to what is happening. Now, so your lordships will have a look at this. Now, I'm just summarizing because I might just tell you that the photographs are extremely graphic, and the photographs are sometimes taken also from a feed. So, you know, obviously for a report, it's the best one which is captured, etc. So if you're seeing it in real time, you may not be able to really see the bull being whipped unless you really focus on it, etc. But let's keep that all aside. Let's go by the text. Please examine by the text. If your lordships have the time and the inclination, please also look at the photographs, because they cement our submission with regard to the cruel and unusual treatment which precedes this. This is not some sort of an entertainment where the bulls are being walked through a crowd or anything of that sort. Not at all. There's extreme provocation. So this is now the record and the state of the affairs insofar as what we are concerned with now. Now, my lords, I'm done with this report. I'm very grateful. Someone else may refer to the photographs in their time. Now, I want to just state the point, and I am here departing from the practice of reading and presenting only constitution bench judgments of a strength of 5+, because we were not able to find this. So I'm just mentioning 2 paragraphs from a decision of a 2-judge bench judgment. It's got nothing to do with this case as such, but it's got a very important principle which may apply. on the bills of attainder. Now, this is a two-judge bench judgment reported at 2015 for SCC 400. And the relevant paragraphs are just paragraphs 13 and 14. I'll repeat the name. It goes under the title S.T. Sadiq versus State of Kerala, 2015 for SCC page 400. And this is not because this is in any manner binding, etc. But it's a historical peep into what used to happen and which now under the separation of law doctrine has been stopped and stymied in some places by constitutional provisions, as in the United States, as this court notes. So basically, there appears to be, at least on my understanding, a certain nature of acts of British Parliament called bills of attainder, where the Parliament itself would pass an act saying X or Y or Z is guilty. And the courts pushed back at that time and said that, look, this is ridiculous, in the sense they, of course, didn't have those powers. The courts there were also marking out their terrain. Then in the US Constitution, as this court notes, there was a specific constitutional provision that you can't have a factual determination and a judgment in an act. So if you just go straight away to page 411, I don't know whether those books have been placed to with the court. This is 2015 for SEC 400. Paragraphs are 13 and 14. Para 13 at the foot of page 411. It is settled law by a catena of decisions of this court that the legislature cannot directly annul a judgment of a court. Sorry. Oh, I'm so sorry.
See, Shyam, we will read that. Paragraph 13 and 14.
Yes. So don't, let's not burn. I will read it. It's not something, but it's interesting. It's settled law by a catena of decisions of this court that the legislature cannot directly annul a judgment of a court. The legislative function consists of making a law and not in declaring what the law shall be. If the legislature were at liberty to annul judgments of the court, the ghost of bills of attainder will revisit us to enable legislatures to pass legislative judgments on matters which are inter partes. Interestingly, in England, the last such bill of attainder was passing a legislative judgment against a man called Fenwick was passed as far back as 1696. A century later, the US Constitution expressly outlawed bills of attainder. See Article 1, Section 9. It is for this reason that our Constitution permits the legislature to make laws retrospectively, which may alter the law as it stood, where a decision was arrived at. It is this limited circumstance that a legislature may alter the very basis, etc. So anyway, I don't want to now repeat myself on the point that this was on a factual determination, and you can't now by a judgment. What have they done, Manoj? I'm just asking. Why are we citing this decision or this concept of bill of attainder? What have they essentially done? What happened in Mulla Periyar? Basically, they said that, look, instead of 142, whatever, 132 feet is safe and anything above that is not. So they made a factual determination, a judgment, and appointed under a legislature, under a board to examine this issue of safety after it had been determined by this court. Now, what is happening over here? After this court has made a determination that this is cruel treatment inherently, Jallikattu and those races and those bullock cart races, having regard to the anatomy of the bull and the creature and its the manner in which, whatever, it's a sentient animal. So all of that. Having determined that, you now have a legislature saying, negating it by a bill of attainder or the equivalent, and saying that now we decide and say that as far as Jallikattu is concerned, the Supreme Court may have said this, it is not founded on cultural rights, but we say it is based on cultural rights. The Supreme Court has said that there is there is cruelty inherent to this, but we say that there's a carve out and this is not covered under the Prevention of Cruelty Act. This is nothing but a bill of attainder in disguise. They have decided the issue, they have finalized the issue, and now they are, and this is a creep into the powers and authority of this court, which in our respectful submission ought not to be countenanced. So this is broadly the submission that we have. Now, let me just indicate the point, and then we will just give me that. Just a minute. Now, Manoj, sorry. Now I'm just on the next point that I wish to make. Now, what had happened over here, it arises actually in two contexts. and I'll just state them. This court was confronted with a situation, inter alia, where we had a decision, which your Lordship would recall, called Nas Foundation, which was rendered by the Delhi High Court. And basically, they just interpreted and declared the law that insofar as consensual sex between two adults is concerned, the statutory provisions, etc., would not apply. It was decriminalized. That was the extent of the judgment. That came up before this court, and we had a judgment which was rendered by this court in a case titled Kaushal. And the case and the Kaushal judgment essentially reversed the Delhi High Court judgment. That was a panel of 2 learned judges. Now, subsequently, the matter came to be examined by this court, sitting in a panel of 5 learned judges. Now, one of the arguments which was made was that when you have, for example, a constitutional court like the Delhi High Court rendering a final determinative judgment, and people are guided by that judgment, there is an expansion of rights. There's an expansion and an extension of rights in a manner of speaking, because the court has decriminalized something like. So therefore, human conduct in a society as vast and varied as ours also where changes. People are accepting of that particular state of affairs, etc. Now, in this context, the argument which was advanced is that now, having moved this distance, it is no part of the duty of this court to retreat. No one suggested that this court is robbed of its appellate power. Not at all. Of course, this power, appellate power, continues. Jurisdictionally, the judgment can be reversed. There's no doubt about any of that. But in the context of human rights, and in our case, it's a little different. It's a case, there's an expansion of certain body of rights, duties, obligations. There's an articulation by the court based on principles under the directive principles of state policy, etc. In a situation such as that, there's a progression. When you progress, there's a global human rights. I'm not saying animal rights, not yet. But perhaps your lordships, we are commending this to the court. Perhaps you may consider it appropriate. So in the world of human rights jurisprudence, when the law moves forward, at least through the court process, it doesn't retreat. So our request is that this principle has been recognized by this court, which is what I'm going to place, the progressive realization of rights under this whole notion that our constitution is a living document and therefore our rights can expand, etc. And that is the citation which I'd like to place. So this judgment is a Constitution Bench judgment. It's reported at 2018, 10 SCC, page 1. Yes. And I'm just going to give you the paragraphs because I've given you the full background, so your lordship need not go into the facts. The title of the case is Navtej Singh Johar. We find this portion, there is a plurality of decisions. The one I am relying upon is paragraphs 201 and 202 from Chief Justice Deepak Mishra's judgment. I'll just read it. Para 201 onwards, the doctrine of progressive realization of rights as a natural corollary gives birth to the doctrine of non-retrogression. You can't go back now, having moved forward. As per this doctrine, there must not be a regression of rights. In a progressive and ever-improving society, there is no place for retreat. The society has to march ahead. The doctrine of non-retrogression sets forth that the state should not take measures or steps that deliberately lead to the retrogression on the enjoyment of rights, either under the Constitution or otherwise. The aforesaid two doctrines lead us to the irresistible conclusion that if we were to accept the law enunciated in Kaushal, which I mentioned, it would definitely tantamount to a retrograde step in the direction of the progressive interpretation of the Constitution and denial of progressive realization of rights. It is because of Suresh Kaushal's view gets wrongly embedded with the minuscule facet and assumes criminality on the bedrock of being guided by a sense of social morality. It discusses about health, which is no more a phobia, and is further moved by the popular morality while totally ignoring the concepts of privacy, individual choice, and orientation. Orientation, in certain senses, does get the neuro impulse to express while seeing the other gender. That apart, swayed by data, Suresh Kaushal fails to appreciate that the sustenance of the fundamental rights does not require majoritarian sanction. Thus, the ruling becomes sensitively susceptible. This is how the court concludes. But I think this is an important principle, albeit in the sphere of human rights. We are not in that sphere here.
How would you quantify
Yes.
rights?
Quantify.
You're talking about progression.
Yes. Oh, very well. I will answer that. So when I talk about what I meant by progression of rights, I mean the expansion of rights. So let me give you the simplest example. First, we have derivative rights. So these are inarticulated rights. I'm sorry.
Somebody is riding a two-wheeler.
Yes.
The state imposes a duty to wear a helmet.
Yes.
Is it a progression of right or is it a
I think it is.
regression of right?
No, I think it's progressive.
No, because here it's a duty is cast.
Yes, it may be.
Unless you wear it, there will be a penalty.
Correct. But it is a progression because you are saving lives. It's a step and a measure in the interest of saving lives of the person.
Expanding the right or by limiting?
Well, I suppose, well, in my mind, I have complete clarity, but that may not be another person viewing the same fact situation which your Lordship is putting to me. To me, in the example which your Lordship gives, it is to preserve life, it's to preserve, prevent motor accidents or whatever, if there's a motor accident, protect lives.
Throughout the Western world, this anti-vax movement went on.
Yeah, that's a
whether that's a progression of right or a...
So let me just answer progression of rights. Let me answer it.
Anyway, maybe in this case, you are not called upon.
No, but I think the question is important. Let me give you a contemporary example. And that is the 9-judge bench judgment of this court in the judgment titled Puttaswamy. In Puttaswamy, the union, we had 30 years of judgments of the Supreme Court saying there is a right to privacy, which is embedded in Article 9. Your Lordship recall. Nevertheless, the union government said there is no right to privacy and harked back to a 1950s judgment of a larger strength, etc. Therefore, it fell on this court in a panel of 9. Now, privacy is not mentioned. Privacy is a derived right. It's a progressive realization of rights. And that is how it was anchored on the basis of various rights. The Lordship said, well, it's a portable right. That it's in 21, but it's also in 19. It also moves to 14.
Normally 14, 19, 21.
Absolutely, 14, 19, 21. And there may be facets of privacy which even lie outside this triangle, etc. So, I will not take very long, but will your Lordship permit me to continue on whatever date the court considers?
Your Lordship sitting tomorrow in the same bench?
Same.
Oh, very well.
There was some confusion in the listing.
Continue tomorrow. Same bench.
Obliged, Lordship. You know,